Hello viewers, today we will discuss the topic cyber offences. The advancement of technology has made man dependent on internet for all his needs. Internet has given man easy access to everything while sitting at one place. Social networking, online shopping, storing data, gaming, online studying, online jobs, every possible thing that man can think of can be done through the medium of internet. Internet is used in almost every sphere. With the development of the internet and its related benefits, also developed the concept of cyber crimes. Cyber crimes are committed in different forms. A few years back, there was a lack of awareness about the crimes that could be committed through internet. In the matter of cyber crimes, India is also not far behind the other countries, where the rate of incidence of cyber crime is also increasing day by day. The introduction of internet has brought the tremendous changes in our lives. People of all the fields are increasingly using the computers to create, transmit and store information in the electronic form. Instead of traditional papers, documents, information stored in electronic form has many advantages. It is cheaper, easier to store, easier to retrieve and for speedier to connection. Though it has many advantages, it has been misused by many people in order to gain themselves for the sake or otherwise to harm others. The high and speedier connectivity to the world from any place has developed many crimes, and these increased offences led to the need of law for protection. Some countries have rather been vigilant and formed some laws governing the net. In order to keep in pace with the changing generation, the Indian Parliament passed the law Information Technology Act 2000. The IT Act 2000 has been conceptualized on the United Nations Commissions on International Trade Law, model law you can say. The increased rate of technology in computer has led to enactment of Information Technology Act 2000. The converting of the paperwork into the electronic records, the storage of electronic data has led tremendous change in the scenario of the country. The Act further amends the Indian Penal Code 1860, the Indian Evidence Act 1872, the Banker Books Evidence Act 1891 and the Reserve Bank of India Act 1934. Now we will discuss what are the offences. Cyber offences are the unlawful acts which are carried in a very sophisticated manner in which either the computer is the tool or target or both. Cybercrime usually includes unauthorized access of the computers, data digging, virus swarms, theft of computer system, hacking, denial of attacks, logic bombs, Trojan attacks, internet time theft, web jacking, email bombing, salami attacks or physical damaging computer system. The offences included in the IT Act 2000 are as follows. The one category is tampering with computer source document, another one is hacking with computer system, the third one is publishing of information which is obscene in electronic form or power of the controller to give direction, then directions of the controller to the subscriber to extend facility to decrypt information, protected system, penalty for misrepresentation, penalty for breach of confidentiality and privacy, penalty for publishing digital signature certificate false in certain particulars, publication for fraudulent purposes, act to apply for the offence or contravention committed outside the India, confiscation, penalties or confiscation not to interfere with other punishment, power to investigate offences. All these are offences which is defined under IT Act 2000. Now we will discuss section 65. Section 65 defines tampering with computer source document. Whoever knowingly or intentionally conceals, destroy or alter or intentionally cause an other to conceal, destroy or alter any computer source code used for a computer, computer program, computer system or computer network when the computer source code is required to be kept or maintained by the law for the time being in force shall be punishable with imprisonment up to 3 years or with fine which may extend up to 2 lakh rupees or with both. For the purpose of the explanation, computer source code means listing of the programs, computer commands, designs and layout and program analysis of computer resource in any form. The main object of this section is to protect intellectual property invested in the computer. It is an attempt to protect the computer source, document, their codes beyond what is available under the copyright law. Essential ingredient of this section is, the very first one is knowingly or intentionally concealing, then knowingly or intentionally destroying, then knowingly or intentionally altering, then knowingly or intentionally causing others to conceal, then knowingly or intentionally causing another to destroy, then knowingly or intentionally causing another to alter. This section extends towards the Copyright Act and helps the company to protect their source code of their programs. Penalties is defined under section 65 is tried by any magistrate. This is cognizable and non-bailable offence. Penalty is up to 3 years imprisonment or fine of 2 lakh rupees. Then we will discuss the provision of section 66 which defines hacking with the computer system. The very first ingredient is, whoever with intent to cause or knowing that he is likely to cause wrongful loss or damage to the public or any person destroy, deletes or alter any information residing in a computer resource or diminishes its value or utility or affect it injuriously by any means commits hacking. Whoever commits hacking shall be punished with imprisonment up to 3 years or with fine which may extend up to 2 lakh rupees or with both. This section tells about hacking activity. Essential ingredient of this section is, whoever with intention or knowledge causing wrongful loss or damage to the public or any person, destroying or altering any information residing in a computer resource or diminishes its value or utility or affects it injuriously by any means. Penalties are imprisonment up to 3 years and fine which may extend to 2 lakh rupees or with both. Then we will discuss the provision 60 section 66A which defines punishment for sending offensive messages through communication services etc. Any person who sends by means of a computer resource or communication device any information that is grossly offensive or has menacing character or any information which he knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred or ill will persistently by making use of such computer resource or communication device, any electronic mail or electronic mail messages for the purpose of causing annoyance or inconvenience or to deceive or to mislead the addressee or recipient about the origin of such messages shall be punishable with an imprisonment for a term which may extend to 3 years and with fine. For the purpose of this section, the term electronic mail message means a message or information created or transmitted or received on a computer, computer system, computer resource or communication device including attachment in text, images, audio, video and any other electronic record which may be transmitted with the message. Then we will discuss section 67 which defines publishing of obscene information in electronic form. Whoever publishes or transmits or causes to be published in the electronic form any material which is lascivious or appears to be prurient interest, or if its effect is such as to tend to deprave and corrupt persons who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it, shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 1 lakh rupees, and in the event of second subsequent conviction with imprisonment of either description for a term which may extend to 10 years and also be with fine which may extend to 2 lakh rupees. Essential ingredients of this sections are publishing or transmitting or causing to be published pornographic material in electronic form. Penalties are, in the first conviction, imprisonment which may extend to 5 years and fine up to the first conviction which may extend to 1 lakh rupees. On the second conviction, imprisonment of which may extend to 10 years or fine may extend to 2 lakh rupees. In this regard, we will discuss one case law on the name of State of Tamil Nadu versus Suhas Katti. This case is about posting obscene, defamatory and annoying message about a divorcee woman in the Yahoo message group. Emails were forwarded to the victim for the information by the accused through a false email account opened by him in the name of the victim. These postings resulted in annoying phone calls to the lady. Based on the complaint, police nabbed the accused. He was known family friend of the victim and was interested in marrying her. She married to another person, but that marriage ended in divorce and the accused started contacting her once again, and her reluctance to marry him, he started harassing her through the internet. The court held that the accused is found guilty of offences under section 469 and 509 of IPC and section 67 of IT Act 2000, and accused is convicted and is sentenced for the offence of rigorous imprisonment for 2 years under section 469 of IPC and to pay fine of rupees 500, and for the offence under section 509 IPC sentenced to undergo 1 year simple imprisonment and to pay fine of rupees 500, and the offences under section 67 of IT Act 2000 the rigorous imprisonment of 2 years with the fine of rupees 4,000. All sentences to run concurrently. The accused paid fine amount and he was lodged at the Central Prison, Chennai. This is considered the first case convicted under section 67 of Information Technology 2000 in India. Then any person who fails to comply with any order under subsection 1 shall be guilty of an offence and shall be liable on a conviction to an imprisonment for a term not exceeding 3 years or a fine not exceeding 2 lakh rupees or both. Any person who fails to comply with an order under subsection 1 of the above section shall be guilty of an offence and shall be convicted for a term not less than 3 years or with fine which can exceed 2 lakh rupees. Then we will discuss section 69, direction of the controller to a subscriber to extend facilities to decrypt information. If the controller is satisfied that it is necessary or expedient so to do in the interest of the sovereignty or integrity of India, the security of the state, friendly relations with the foreign states, or public order, or for preventing incitement to the commission of any cognizable offence for reasons to be recorded in writing, by order, direct any agency of the government to intercept any information transmitted through any computer resource. The subscriber or any person in charge of the computer resource shall, when called upon by any agency which has been directed under subsection 1, extend all facilities and technical assistance to decrypt the information. The subscriber or any person who fails to assist the agencies referred to in subsection shall be punished with an imprisonment for a term which may extend to 7 years. Penalty is punishment, imprisonment for a term which may extend to 7 years. The offence is cognizable and non-bailable. Section 70 of the IT Act defines protected system. The appropriate government may, by notification in the official gazette, declare that any computer system or computer network to be protected system. The appropriate government may, by order in writing, authorize the person who are authorized to assess protected system notified under subsection 1, any person who secures, assesses or attempts to secure access to a protected system in contravention of the provision of this section shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. The explanation of this section grants the power to appropriate government to declare any computer system, computer network to be protected system. Only the authorized person has right to access to protected system, and again penalty is 10-year imprisonment or fine. Then we will discuss section 71, which will define penalty for misrepresentation. Whoever makes any misrepresentation to suppress any material fact from the controller or certifying authority for obtaining any license or digital signature certificate, as the case may be, shall be punished with imprisonment for a term which may extend to 2 years or which fine which may extend to 1 lakh rupees or with both. Penalties again 2-year imprisonment and 1 lakh rupees fine or with both. Then we will discuss section 72, which defines penalty for breach of confidentiality and privacy, save as otherwise provided in this act or any other law for the time being in force. Any person who, in pursuance of any of the powers conferred under this act, rules, regulations made thereunder, has secured access to any electronic record, book, register, correspondence, information, document or other material without the consent of the person concerned, discloses such material to any other person, shall be punished with imprisonment for a term which may extend to 2 years or with fine which may extend to 1 lakh rupees or with both. The explanation of this section defines any person who, in pursuance of any of the powers conferred by the Act or its allied rules and regulation, has secured access to any electronic record, books, register, correspondence, information, document or other material. If such person discloses such information, he will be punished with punishment. It would not apply to the disclosure of personal information of a person by website by his email service provider. Penalties are: punishment term may extend to 2 years and fine can extend up to 1 lakh rupees. Then section 73, penalty for publishing digital signature certificate falls in certain particulars. No person shall publish a digital signature certificate or otherwise make it available to any other person with knowledge that the certifying authority listed in the certificate has not issued it, or the subscriber listed in the certificate has not accepted it, or the certificate has been revoked or suspended unless such publication is for the purpose of verifying a digital signature created prior to such suspension or revocation. Any person who contravenes the provision of subsection 1 shall be punished with an imprisonment for a term which may extend to 2 years or with fine which may extend to 1 lakh rupees or with both. The certifying authority listed in the certificate has not issued it, or the subscriber listed in the certificate has not accepted it, or the certificate has been revoked or suspended. The certifying authority may also suspend the digital signature certificate if it is of the opinion that the digital signature certificate should be suspended in public interest. Digital signature may not be revoked unless the subscriber has been given an opportunity of being heard in the matter. On revocation, the certifying authority need to communicate the same with the subscriber. Such publication is not an offence. It is the purpose of verifying a digital signature creating prior to such suspension or revocation. Penalties are punishment for a term which may extend to 2 years and fine which may extend to 1 lakh rupees or both. Then we will discuss section 74, publication for fraudulent purpose. Whoever knowingly creates, publish or otherwise make available a digital signature certificate for any fraudulent or unlawful purpose shall be punished with imprisonment for a term which may extend to 2 years or a fine which may extend to 1 lakh rupees or with both. This section prescribes punishment for following act. The one is knowingly creating a digital signature certificate for any fraudulent purpose, unlawful purpose, knowingly publishing a digital signature certificate for any fraudulent or unlawful purpose, knowingly making available a digital signature certificate for any fraudulent purpose or unlawful purpose, and again punishment is imprisonment up to the term of 2 years and fine up to 1 lakh rupees or both. Section 75 defines act to apply for the offence or contravention committed outside India. Subclause 1 subject to the provision of subsection 2. The provision of this act shall apply also to any offence or contravention committed outside India by any person irrespective of his nationality. For the purpose of subsection 1, this act shall apply to an offence or contravention committed outside India by any person if the act or conduct constituting the offence or contravention involves a computer, computer system or computer network located in India. This section has broader perspective including cybercrime committed by cyber criminals of any nationality, any territoriality. Then we will discuss one case law regarding this, that is R versus Governor of Brixton Prison, another. In this case, the Citibank faced the wrath of the hacker on its cash management system, resulting in illegal transfer of funds from customers' account into the account of the hacker. Later identified as Vladimir Levin and his accomplices. After Levin was arrested, he was extradited to the United States. One of the most important issue was jurisdictional issue, the place of the origin of cybercrime. The court held that real-time nature of the communication link between Levin and Citibank computer meant that Levin's keystrokes were actually occurring on Citibank computer. Section 76 defines confiscation. Any computer, computer system, floppies, compact discs, tap drives or any other accessories related thereto in respect of which any provisions of this act, rules, orders or regulations made thereunder has been or is being contravened shall be liable to confiscation, provided that where it is established to the satisfaction of the court adjudicating the confiscation that the person in whose possession, power or control of any such computer, computer system, floppies, compact discs, tap drives or any other accessories relating thereto is bound not responsible for the contravention of the provision of this act, rules, orders or regulations made thereunder. The court may, instead of making an order for confiscation of such computer, computer system, floppies, compact discs, tap drives or any other accessories related thereto, make such other order authorized by this act against the person contravening of the provision of this act, rules, order, regulation made thereunder as it may think fit. The explanation of said section says, highlights that all the devices, whether computer, computer system, floppies, compact discs, tape drives, or any other storage, communication, input or output device which helped in the contravention of any provision of this act, rules, orders, regulation made under their under liable to be confiscated. Section 77 defines penalty or confiscation and interference with other punishments. No penalty imposed or confiscation made under this act shall prevent the imposition of any other punishment to which the person affected thereby is liable under any other law for the time being in force. The aforesaid section lays down a mandatory condition which state that penalties or confiscation not to interfere with other punishments to which the person affected thereby is liable under any other law for the time being in force. Section 78 define power to investigate offences. Notwithstanding anything contained in the Code of Criminal Procedure 1973, a police officer not below the rank of Deputy Superintendent of Police shall investigate any offence under this act. The police officer not below the rank of Deputy Superintendent of Police shall investigate the offence. In concluding remarks, we must say due to the increase in the digital technology, various offences has also increased. Since new technology come every day, the offences has also increased. Therefore, for the IT Act 2000 need to be amended in order to include those offences which are now not included in the Act. In India, cybercrime is of not a high rate. Therefore, we have time in order to tighten the cyber laws and include the offences which are not included in the IT Act 2000. Thank you viewers for watching this program.